All rise. Turn this back in session.
Hey, you gotta move that. I'll move when I talk to Joey. Joey knows I'm out here waiting. He needs to come out and talk to me. I'll move when I talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law just for parking in a spot that says reserved for the sheriff's department.
One more time.
I'm here at the sheriff's department.
Move, or you will go to jail for disorder.
I'm not being disordered. I'm moving my car. I'm moving my car. I was moving my car. Ah! Really? Ah! I said I was moving my car. Oh! Stop! Ah!
Before we proceed, I want to make sure that certain rules are followed. Rule 1.03, the use of cameras, recording, or broadcasting equipment, or such shall be governed by the Code of Judicial Conduct. A couple of years ago, the law was changed as far as recording in courts. The bigger courts are allowed to record. So the Justice Court Rule 1.03, cameras or recording devices should still not allowed in justice courts or municipal courts. So, Mr. Reardon, I want to make sure that you understand there shall be no recording of this.
Your Honor, I had questions about that. I had questions about that, Your Honor. It's my understanding Justice Court...
Mr. Reardon, I understand the question. It shall not be permitted.
Okay.
As far as a recording device, camera, or anything as far as this hearing is concerned, it shall not be allowed.
Can I put a motion before the court for that?
Mr. Reardon, the motion. That is.
Mr. Reardon, you have made a motion before this court, a motion to dismiss with prejudice.
Yes, Your Honor.
Would you please explain your motion?
Well, Your Honor, I had, after the arrest, approximately, it was within 2 weeks after that, I put in a motion for, actually it was a subpoena, Duces Tecum. My reason for such was that I reached out to the Lafayette County attorney, David O'Donnell, for guidance as to whether or not the county was going to cooperate with a discovery request for the information that I was seeking. In particular, each camera that viewed the parking lot of the Lafayette County Sheriff's Department. I also wanted the booking area of the jail where I was restrained for upwards of an hour upon being brought in, as well as held an additional day to speak to the sheriff. And I was denied the information that I was seeking on the subpoena Duces Tecum. The prosecution actually got to pick and choose what they wanted me to see, which was one camera scope, one camera angle, and just slowing the tape down, zooming in. There were quite some disturbing finds on that video that definitely warrant the additional angles.
Mr. Reardon, I understand you represent yourself. I was saying, are you familiar with Mississippi Rules Criminal Procedure 17.10?
Somewhat, Your Honor.
Anything else you wish to add?
I have the right to a fair and impartial trial, and this is the entire time of the last 3.5 years has been nothing more than just a targeting witch hunt, Your Honor. I would just like to get fair treatment. That's all I've sought. In fact, this charge stems from me just seeking out to the sheriff, reaching out to the sheriff, trying to get the equal protections under the laws after I was targeted by my ex-girlfriend on a false charge.
The prosecutor?
Yes, Your Honor. I'm familiar with the rules cited, Rule 1710, discovery in municipal and justice courts. Of course, just for the court's record, I need to bring it up. That was the nature of my response to this subpoena Duces Tecum, and that's not an unusual item that I see quite frequently, a subpoena Duces Tecum. If it's exculpatory, that means it proves that the defendant did not do it. I'm supposed to give that up regardless if I get a request or not. And I attempt to do that, you know. Sometimes I don't have that information. But as you can see, that's set out in Rule 1710. It's codified based upon the prior rulings. A copy of any exculpatory material concerning the defendant. Of course, any physical evidence, photographs, and/or electronic data should be offered into evidence. Of course, another important words in here too. Should be offered into evidence. If they exist, and I don't intend to offer them, I don't have to give them up. But I read that. I say, out of fairness, I'm going to give the guy. If I know that we've got a video out there, photographs, I'm going to give him. Of course, I've given him photographs of himself as well as that video from the camera out front of the jail. Affidavit to use became search warrant. No search warrant there. And then the prosecution's going to continue with supplementing disclosure previously. It's a security issue. They're also there for a relevancy issue. Everything that led to the arrest of Mr. Reardon occurred on the outside of the sheriff's department. And that's depicted on that video that was supplied sometime ago. So I think it is motion for dismissal or an alternative transfer. He's complaining that I, for that reason, and those items sought, or in my opinion, why I filed a motion to quash, not discoverable and or outside what this court is going to deal with as relates to the criminal charge at present.
Mr. Reardon, any response to that?
Yes, Your Honor. So, what Mr. Chain showed off was typical.
I'm loyal, Jack. You know, if he wants to comment to the rules, he can do. He doesn't get to personalize things. He can talk to the tribunal. I object to anything that's extemporaneous as relates to that. If he wants to argue the state of the law, let him be a lawyer and argue the state of the law.
I'm not trying to.
We gotta keep it on the point.
Yeah, all right. He's going to tell me, I'm not trained to be a lawyer. Well, it's his choice. Anybody in this country can act pro se, but they're held to the same standard as a lawyer. These books, they're on the internet.
Why can the same standard not be applied across the board evenly when it comes to anything in Lafayette County? Because that's the whole reason we're here right now, Your Honor.
Mr. Reardon, let me stop you there. We're not gonna get into anything in the past or what happened. I'm here for a motion before this court on a case that is scheduled to be tried March 22nd.
Yes.
That is what we're here about. As far as any conspiracy or anything like that,
There's a federal lawsuit filed.
don't want to hear that. I'm here for this motion before the court of the discovery request you have made. Do you have anything you wish to add to that?
I do, Your Honor. I mean, you have my car being searched by 8 sheriff's deputies.
We're not trying to, okay, let me stop you there. We're not gonna try a case today. You have made a motion before this court as far as your subpoena, as far as discovery is concerned. That is what we're here about.
Your Honor, my rights basically can get trampled on and me not have any kind of recourse.
You're right,
Me
I'm
not being
being
able to get.
done in this court. You're talking about something in the past. We're not here to, determine about something that's happened in the past. We're here to determine about 2 charges that was filed against you that comes to trial March the 22nd, correct?
Yes.
That is disorderly conduct and
And Your Honor, I have not tried to delay it. In fact, I've tried to actually speed it up. All I'm simply asking for is the camera that's closest to where the incident actually occurred, which is right in front of Sheriff Joe East's vehicle, which was right in front of my vehicle. It got a different vantage point, and that was specifically the camera that I really wanted to have access to. And I don't think it's asking too much to get the closest camera to where the incident actually occurred in the parking lot.
you're also asking for a transfer.
Well, actually, Your Honor, that was addressed. There was a renewed motion it was a motion to dismiss or the alternative to compel the prosecution to comply with the subpoena due suspended.
They said, Mr. Prosecutor, you get the last vote.
Plenty about the standards, speaking of this well. Obviously, we're here He says that will become mooted or?
I believe he actually had two motions. I believe this may be the motion you're looking for. I believe the first motion on that was asking for the transfer.
And Your Honor, I meant to introduce this. I have a motion for discovery right here for anything that was not included.
I've got it based on the rules, but I'm giving everything that that's the Supreme Court said. So I mean, we don't know where we are on that as relates to these other information. Rule 33 requires that he tell us why he wants these things, why they're relevant.
I think I've done that.
Not relevant, you know. And he's seeking discovery for both other matters and other courts. Of course, those courts and those matters likewise have a set of rules of their own. There's FOIA requests, freedom of information requests. The criminal side never sees. Don't know what that's don't know how to.
Objection, Your Honor.
The prosecutor has the right to speak at this time.
And, that's where we are. If he's seeking discovery for federal court suits, there's a process to seek or discover items in that process, but not in the prosecution of him as relates to the events that occurred on 21 March or occurred back in 28 December.
This court is here today not to relive anything that's happened in the past. We're here to hear a motion that has been presented to this court as far as the motion for discovery, and has discovery been provided. Mr. Reardon, we're a country and state of laws.
Yes, Your Honor, we are.
I'm a firm believer for a fair and independent judicial system. And in simple layman's terms, you have been provided discovery as far as what is required to go to trial on March 22nd.
But what is the county trying to hide so bad with the closest
Mr.
to?
Reardon, you keep on interrupting this court, and you will be held in contempt, and
Yes,
you
sir.
will go to jail. I will not be interrupted again. Do you understand that?
Sorry, Your Honor.
As far as the motion to transfer, this court is a fair and just court that will determine this case on the facts presented in the courtroom March 22nd. As far as your motion to dismiss this case, the motion is denied. Discovery request has been provided to you. We are governed by the Mississippi Rules of Criminal Procedure, Rule 1710, also Rule, which the prosecutor said, Rule 33. I'm sitting here looking at the rules of discovery. The rules of the discovery have been met by the prosecution. This will be heard on March 22nd at 9 o'clock. Motion denied. Court adjourned.
I'll move when I talk to Joey. Joey knows I'm out here waiting. He needs to come out and talk to me. I'll move when I talk to Joey. When Joey wants to talk to me, I'll move. Otherwise, I'm not breaking any law just for parking in a spot that says reserved for the sheriff's department. I'm here at the sheriff's department.
Or you will go to jail for disorderly.
I'm not being disorderly. I'm moving my car. I'm moving my car. I was moving my car. Ah! Really? Ah! I said I was moving my car. Oh! Stop! Ah!
So I can always do an appeal to the Supreme Court. And if everything is on paper and motions and filings, it'll be easy for it to go to the Supreme Court, and the Supreme Court be able to see everything laid out and see that I was completely ignored. I said, Mr. Chan, may be referring to a typical scenario, a typical case. This is everything but typical. This is, what is it that Lafayette County is trying so badly to hide and to cover up? Your obstructionist tactics. The camera that is closest to where everything occurred. The camera closest, when there were already several bizarre things that were captured on video, especially when slowed down. You know, and the camera angle that's the closest to everything, that sees everything from a different standpoint. They will not comply with, nor the camera inside, you know, the booking area of the jail. And, I mean, Judge Avent refused to freaking entertain my argument. And he wanted to say whatever conspiracy outside of here. I was like, it's not a conspiracy. I mean, like, the things that I've brought forth are things based on fact. That's the reason why I've asked for them. It's these obstructionist clowns that are keeping that stuff back. They're trying to cover it up, and they want to label it as as I'm freaking fishing conspiracies. No, it's my life that got destroyed based on all these, all the shenanigans that happened in Lafayette County, and now you got a unlawful search and seizure with 8 different sheriff's deputies in my car, and you have what would easily appear to be a highly unlawful arrest. He wouldn't let me introduce evidence. I mean, I slapped a motion for discovery on the table and said, I'd like to enter this to cover anything that had not been given to me off of the subpoena ducis tecum, and re-raise the subpoena ducis tecum. Because there's camera angle, it would only make sense for me to get the closest camera to where everything happened. That's what only makes sense. Why would you give me a camera from further away? And whenever I've already asserted certain claims, and why would you? I'm at the gas pump, by the way. Why would you refuse to give me the closest camera? None of that makes a single bit of sense. But of course, the only thing that mattered was anything directly related to the fucking arrest, which I tried to assert everything had to do with the arrest, because it was freaking, it was that was the reason that I even went up there in the first place. I sent Joey East an email based on what Liz had done. I mean, my motions were denied, and I was threatened with jail for contempt. Yeah, because I got fucking mad at the end. Like it was like I wasn't being heard whatsoever, and just the obvious was being ignored. And I thought this was a complete witch hunt, and I said that.